afternoon, and welcome to the Employer Link webinar series presented by McAfee Taft. My name is Brad Neese, Managing Editor of Employer Link. Welcome to everyone joining our broadcast today. We have 14 states from around the country represented here in our audience, and from as far away as the East and West Coast, as well as the southern and northern borders. We even have a few friends joining us today from north of the border representing Canadian companies with operations and employees in the U.S., and so a special welcome to them as well. Based on the number of people registered, this is obviously a hot topic for many employers, so we're excited about today's presentation. But before we get started, I want to let you know about our next big event coming in just a few weeks. If you joined us for our last webinar, we mentioned during the broadcast that we were waiting for the Supreme Court's long-awaited ruling on the health care reform law. The following morning, the court finally issued its landmark majority decision upholding the constitutionality of that law, a ruling that caught many industry and legal experts and prognosticators by surprise. And that result has left many employers asking, now what? To help answer that question, the employee benefits attorneys at McAfee Taft will be hosting complimentary half-day webinars in both Oklahoma City and Tulsa to discuss the impact of the law going forward. They'll be providing a timeline of essential deadlines as well as action steps necessary to maintain compliance in the coming year and beyond. This seminar will be held on Wednesday, August 22nd in Oklahoma City and Thursday, August 23rd in Tulsa. And if our early registration numbers are any indication, this is going to be a well-attended event, so we encourage you to sign up early because space is limited. You can register today at employerlink.com/seminar. Now just a few notes about today's presentation. This program has been approved for 1 hour of general recertification credit through the HR Certification Institute. And for those who pre-register for HRCI credit, we will be sending a follow-up email in the next day or so with program details about today's webinar for recertification submission. Second, on your screen, just below the slide presentation area, you should see a tab called Supporting Material, which allows you to download a PDF version of today's presentation materials. Right next to that tab, you should see another one called Ask a Question. You can submit your questions electronically during the presentation. Our presenters may address some of those questions if time permits before the end of the broadcast. Even if we are not able to get to any or all of those questions, we will post answers to the most frequently asked questions by early next week on this webinar's resources page at employerlink.com. We'll also provide a link to that page when we send out our follow-up survey. I would also point out that if you want to submit a question, please keep in mind that we are not able to answer case-specific questions in this forum. For those questions, we recommend that you consult your legal counsel about the unique issues in your specific situation. Now let's meet today's presenters. Joining us are Neal and Sharolyn Whiting-Ralston, both of whom are trial lawyers with McAfee Taft. Both represent employers in all phases of labor and employment law, including complaints and disputes before state and federal courts, regulatory administrative agencies, and arbitration panels. Their extensive experience includes counseling clients on the full spectrum of employment issues and defending employers against discrimination, harassment, retaliation, and other types of employee claims. They are both frequent speakers locally and nationally, as well as contributing writers to industry and professional publications on this very topic, along with other employment law issues. So, Sharolyn, to get things started, can you tell us why this topic is such an important one for employers?
Sure. Thanks, Brad. Well, harassment and other types of complaints by employees are a growing problem. The numbers seem to increase every year. For instance, the EEOC has reported that 5 years ago they received approximately 23,000 harassment complaints, and last year that number was up over 30,000. So you can see the numbers are increasing every year, and that means that more employers are going to have to deal with harassment complaints, and that gets more and more expensive every single year. So how you deal with those complaints, your investigation, and how you deal with employees after you've received a complaint are crucial.
Dealing with a harassment or other kind of complaint is a tough issue for employers, mainly because the possibilities of what may trigger an investigation are almost infinite. And as you'll see us talk about through this presentation, is there really isn't a magic formula for conducting these investigations. Employers have to make judgment calls on who to interview, how wide the investigation should be, and who is being truthful. The question really for employers is not when or if. The fact is that you will have to conduct an investigation at some point in your life as an HR professional with your company. And so what we are hoping to provide for you today are some basics, some tips and suggestions on what to do and what not to do when the time actually comes for you to conduct an investigation.
And one other thing I want to add about, the importance of understanding how to deal with harassment complaints is the U.S. Supreme Court has held that, particularly with sexual harassment complaints, there is an absolute defense for employers if they have a policy in place about making complaints and then they do the appropriate investigation and make remedies. And so if you do react appropriately, you can find yourself in a really good position should a lawsuit be filed. And so that's another really important part.
Okay, I'm sorry to interrupt real quick. We're getting several questions come in about the inability to download the presentation materials. If it is not working on the webinar presentation site, you can go to employerlink.com. You'll see the website icon there on the top of the front page, and then there's a link to download the presentation materials, and I believe that link is working because we verified it. So I apologize for that, and back to you, Sharolyn.
Sure. Well, we'll just go ahead and get started. And the first thing is, when do you start an investigation? Is it just when you get a complaint? And the answer to that is no. As an employer, it's your responsibility to sort of be aware of things that are going on in your workplace. And so, number one, you may get a complaint, and so that obviously starts, an investigation or triggers an investigation. But you may observe, significant recurring performance or conduct issues that cause you some concern. That may be a reason to start an investigation. Co-employees or supervisors may make complaints. Again, it's not always going to be the person who may be being harassed, but it's also going to be other people who might have observed it, and that triggers a complaint as well. Or you just might discover an issue, in some way, shape, or form, just accidentally. And so the point is that when you have a trigger or you see something that gives you some concern about harassment or maybe even other behavior in the workplace, it's your job as the employer then to start an investigation and to deal with it.
And while we'll talk a lot today about sexual harassment and how you handle those complaints, when we talk about harassment, we're talking about harassment on the basis of any kind of protected characteristic. You may need to do an investigation because there are allegations of theft in the workplace, or an accident may trigger your need to do an investigation. And what we're talking about today really applies to all subjects of an investigation. We're not just sexual harassment.
Absolutely, I agree. So when does an investigation pay off, and when can it actually be a problem? Well, investigations, like I said earlier, will pay off, first of all, if you get sued. If you have received a complaint of harassment and then you've gone and done an investigation and made particular findings, whether or not it's corroborated, your investigation will help you in defending that lawsuit. It'll help you with discipline and discharge decisions. As you're going through an investigation, you may find some other problems. You may be able to correct those before bigger problems arise. You've also got some paper to back up any discharge or discipline decision, and that can help you, again, on down the road. An investigation may help you with unemployment claims in fighting those. For instance, in Oklahoma, technically, a person who has been terminated is not necessarily entitled to unemployment compensation unless they've been terminated for what they call misconduct. Now, that's a fuzzy word, but if you have done an investigation and you've terminated somebody as a result of a really solid investigation, the idea that you terminated them for misconduct is all the stronger. And if you can submit that information, you may not have to pay that unemployment claim. It'll help you during an investigation conducted by a state or a federal agency. You will have already, sort of papered things up. You will already know what's going on. There won't be any surprises that way, or very few surprises, hopefully. Again, in a wrongful or discriminatory discharge case, which is what we're talking about a lot today, or to just preempt or prepare for an inquiry by an outside agency. The EEOC, the Department of Labor, OSHA, a lot of agencies have really amped up the number of just sort of random investigations they're doing. And if you've been doing, sort of investigations when you receive harassment complaints or any other type of complaint, you're prepared. You're all the more ahead. And so there's a lot of benefits to doing them. Now, investigations, if they're not done properly, can hurt you. And the only thing worse than not doing an investigation
is a bad one.
Is a bad one, exactly. Yeah. If you conduct a bad investigation, you can just expect that to be Exhibit A, and it's going to be all over the place in your lawsuit. So the important thing to do is to make sure that when you do an investigation about a complaint of harassment or any other type of workplace issue, that you do it appropriately. And so we're going to take you through some of those tips on that today. Another thing about doing an investigation is you may not like what you find, and then it may obligate you to act in a way that you don't really want to. For instance, you may have a high-level, executive that gets accused of harassing behavior, and you do an investigation, and you find out it's true.
And it's been going on for a long time.
Yeah, and it's that doesn't go well. But you're going to have to act at that point. And so, you may find out things that you don't like, but the truth is as an employer, you are better off knowing if you've got problems on down the road. And so they can occasionally hurt you.
So as you set out on this investigation, you ought to have certain objectives. Your first one is to determine facts and make a good, well-informed decision. So you want to conduct this investigation promptly, you want to be careful, you want to be thorough, and you want to be fair. And primarily, as a result of this investigation, you want to create a record of what you did, how you investigated, and the facts that you discovered in this investigation. And we'll talk a little bit more about that later on. But those are your objectives as you start out.
Kathy, don't you think that when you're getting ready to do an investigation, you should go into it just expecting that it's going to be used at trial or something's going to go to trial?
Absolutely. In fact, you are making, in your investigatory report, we'll talk about this too, you are making your defense exhibit. That's going to be Exhibit A. And the person who is the key witness or the star at trial is going to be the person that you select as the investigator. So it's crucial that when you begin the thoughts about how to perform this investigation, as you spend a lot of time picking the right person to do it. Investigations, of course, are going to be time-consuming, and you may be tempted to simply select the person who has the most availability. That person may not be the right person for a particular investigation. You need to make sure that whoever you select to do this is knowledgeable not only about the job positions that are involved, the complainant's job position, the accused's job position, but also about the overall operations of the company. This person ought to have a mastery of your employee policies and your handbooks. This person ought to be knowledgeable about how you've handled situations in the past that are similar to this, needs to know about your past practices because you want to be consistent in how you handle any discipline that might result from your investigation. And this person doesn't need to be a lawyer, but they ought to have a working familiarity of employment laws and concepts of discrimination because they need to be able to recognize issues that are significant, know what a legal pitfall might be in this area, or, like Sharolyn explained earlier, know the legal standard for avoiding liability, know that if you have an effective grievance policy in place and that the employee fails to use that may actually be a defense to you later on down the line.
Kathy, on that topic, one of the things that I think is really important on that particular issue is understanding employment and discrimination concepts legally. Is the investigator again is going to be taking notes, and they're going to be they're going to be writing documents, having conversations, and so frequently the wording of those documents or how something is put in a conversation is going to be crucial. And so if your investigator has knowledge, again, like you said, of pitfalls that are specific, then that is going to be helpful to you.
I agree, 100%. this person needs to have some experience, too, in conducting investigations. And, it may behoove you as an employer to train several people who can conduct these investigations because one may be better at a particular subject matter of an investigation than the other. And it needs to be a person who has kind of an organized way of gathering evidence and the ability to present that evidence in an organized way. And it sounds like I'm talking about a lawyer, but I'm really not. Although we'll talk in a moment. Sometimes lawyers are the appropriate people to conduct the investigation, and we'll explain to you why they may be and why they may not. So when you select this investigator, be thinking that you need someone who is going to be impartial and who's objective, and that is someone who is actually impartial and objective, and someone who will be perceived to be that way. This person is not an advocate. They don't advocate for the employee. They don't advocate for the person who's accused, and they don't advocate for the company. They are truly an independent non-advocate. But in terms of being perceived to be objective, one of the things is that they need to be credible, and part of that credibility is that they need to have sufficient authority to actually thoroughly investigate and compel people to cooperate in the investigation. And they need to have the ability to act on the results, or at least, make some credibility determinations. So generally, within a company, that's going to end up being someone who's sort of a high-level manager or a high-level employee, because that person selected as an investigator, I think, demonstrates to employees involved that this investigation is important to you as the employer. And one thing that I think that the mistake that employees make is they tend to find that they use an investigator over and over again. Maybe it's the HR manager. That can be a problem for you because, let's say your HR manager is a white male, 55 years old, and he just has sort of fallen into the routine of handling these. Well, if you have a sexual harassment complaint where, perhaps there's some embarrassment and maybe some bad words, you may find that a female who's complaining would be more comfortable with a female investigator. And that female investigator may get more of a frank set of facts from employees involved. And then if you have a female investigator and it turns out that investigator finds that there's no reason to think that harassment occurred, then that establishes even more credibility to the judge and the jury. The same might be true with respect to a race discrimination claim or harassment claim. If you have the white male investigator, a jury may think that he or she is more inclined to side with the white male who's been accused, for example, of harassment. So it behooves you, I think, as an employer to have 3 or 4 people who are trained, who understand how to do investigations, and you can select the person that may be the most appropriate one for the particular facts at hand. One thing that is very important is that this person needs to be somebody who has the ability to express himself or herself well. Because obviously this person is, if you get sued and you end up in trial, this person is going to be your star witness. This person is likely going to have to give a deposition. So you want someone who appears well for you, has a professional appearance, and someone who's comfortable with the role, someone who can speak well in public, because you could have the textbook perfect investigation that becomes a problem for you because the person who is testifying about it seems ill at ease or perhaps has some annoying nervous habit that the juries like to focus on, or somehow it comes across as not being credible or untrustworthy.
Well, and additionally, a person who is able to express themselves well is going to be more comfortable when they're in the interview process. The people are probably more likely to respond to them in a favorable manner and provide the information that's being requested. So if you think of them as somebody that you'd want to talk to, or that, like you said, you can put on the stand at trial, I think that's the best way to go.
Think about, too, when you're selecting the investigator, you probably ought to have not only the investigator but somebody there to at least take notes or to at least be the second set of eyes. but maybe you have two people on the investigatory team, somebody who's got that HR experience and then someone who has some operational knowledge. I mean, it doesn't ever hurt to have that second set of eyes, and I like consensus decision-making a lot for an employer, and so the decision does not boil down to a single person who, as it turns out, may have an axe to grind against a particular employer, has a certain set of perceived, notions that come with it, with him or her. Which leads us to, what should you use your attorney? Your first reaction may be, okay, I turn to so-and-so whenever I have an employee problem, so I'm going to pick up the phone and call him or her and have that person conduct this investigation. Well, first of all, as you all well know, we're pretty expensive, so that's disadvantage number one.
So you can go ahead and call us. That's okay.
Yeah. But I think you may find that employees are unwilling sometimes to talk with lawyers. I mean, they watch TV and they think that it can be a miserable experience, and it can be. So I think you may find an employee may be less candid or frank if a lawyer's doing the investigation. But the primary problem with using a lawyer in the investigation is because that lawyer is your witness. And we have a professional responsibility obligation that we cannot represent you if we're a material witness in the case. So we're professionally barred from continuing in the representation. So you have to make a decision whether or not you want us as a witness or do you want us as a lawyer. Obviously, when your lawyer is conducting this investigation and reports back to you, then you're going to lose that attorney-client communication privilege as well. And I think there's a perception, too, among some people that, oh, gosh, they used a lawyer, so they must have known that something really bad was going on here. Our suggestion would be is that use your attorney behind the scenes to help you strategize on which way the investigation should go, who you should talk to next. Is this really something that's important? And use your lawyer to help you write that report that you're going to do at the end. And help you with your witness statements and things like that. Now, there may be times when you want to use an attorney. I've functioned as an investigator several times, and usually that's a client that maybe is an out-of-state client who has an operation in Oklahoma. I'm not going to be the person trying the case, but the outside company wants to know that they can rely upon someone. So there are times when lawyers are used. Sometimes you may want to think about using an outside investigator. Again, this may involve the question of expense. You might want to use an outside investigator when you just don't think you've got someone who's appropriate to do that investigation. Or I think this comes up most often when you've got a senior executive or somebody high up the food chain who is the subject of the investigation. The same principles apply. You're still going to need someone doing this investigation who has authority. So a downside, I think, to using an outside investigator is the expense, but that person would probably be less familiar with your policies, your culture, and they may recommend action, like Sharolyn said, that you're not really prepared to take, like firing the president of your company, which would be a really difficult one. On the plus side, you probably will be able to limit the investigation and the results to those people who really have a need to know. And if you've got someone stepping in from the outside, you might have employees feel like they can be more frank and more responsive because this person really is going to be here today and gone tomorrow. So, Sharolyn, what's the first step we take?
Well, there's several things you're going to do initially whenever you get a complaint of harassment. And obviously the first thing that's going to come into place is somebody's going to come into you and say, here's my complaint. You're going to want to talk to that person and get as much information from that person as possible. Again, the complaining employee may not be the employee being harassed. It may be, but it may not be. So, you want to get as many details as you can. At that point, you want to find out, who else may have witnessed any sort of harassment or the bad behavior. And help sort of get you a guideline as to where you're going to go. But after you get those details and you've determined that you need to do an investigation, you need to stop the alleged problem immediately. This one gets kind of tricky because, one of the things that's frequently happens is you're going to want to separate the employees. If you've got a sexual harassment complaint going on, and let's say you've got two employees who work on the day shift together, and the male has been accused of harassing the female, you're gonna need to separate them, and that may mean moving the alleged harasser to the graveyard shift, and leaving the person who's being harassed on the daytime shift. Now, you need to be really clear and do as best you can to make sure that whatever action it is you take is not a disciplinary action, but really this is a preventative measure at this point.
Yeah, but I've been accused of harassment, and it starts to look like when you take these steps that you've already prejudged me, that I'm guilty.
Yep, and that is a problem that employers have. And so, what I recommend is you bring in the alleged harasser. If you're going to be moving their shift or taking some other action to separate the employees, you bring him or her in and you talk to him. You tell them, we've had this allegation, and just some of the real basics, and that we have to take some action to prevent. We're not saying that you did or didn't do this, but we have to conduct an investigation, and we have an obligation to take some preventative actions right now, and we'll keep you posted as to what's going on. It may not seem fair, and it's particularly not going to seem fair if at the end of the day there's a determination that no harassment has occurred. But again, as the employer, it's your job to take action whenever you find out that something may be going on. Another option, depending on the severity of the allegation, is suspension with pay. And again, you're going to give immediate counseling and direction, to the employees that are involved. Again, whenever you take a step initially to sort of stop the problem, make sure that you try not to disadvantage the person who complained or the person who is allegedly being harassed. Don't move their shift if you can keep from it. Move instead the person who supposedly is doing the harassing, because again, that can be perceived as being some sort of retaliation for making a complaint. So it's best to try and not do that. The other things you're going to want to do is you're going to want to make sure that you protect the employees. And that's going to include the complaining party. If it's not the same person as the person being harassed, also the person being harassed, and then also witnesses. You're going to make sure that they know that retaliation is not going to be tolerated. The company doesn't allow it. You're going to balance the accused's rights of having a fair opportunity to respond as well. And you're also going to, explain to them the process a little bit. Tell them you can't guarantee that this is all going to be confidential, but you're going to do it's going to be a need-to-know basis only. You're going to keep it as confidential as possible.
I think it's very important because what I've found that the first reaction to someone who is accused, for example, of sexual harassment, generally it's someone says, he or she did this, and the accused person says, what are you talking about? I don't even know what you're talking about. That's absolutely wrong. So the first reaction from that person is they're mad. And I've had them march right down to the employee's office and say, what are you doing? What's going on? And so you have to really make sure that the person who's been accused understands we're going to investigate this. Nobody's saying that you did this at this time, but you cannot take any steps that might be considered to be retaliatory.
Absolutely, and I give examples of things. Don't just treat them the same way as you always have.
It's really hard for someone to do that.
Right. Well, you want them to treat them the same way they always have, unless, of course, they're actually doing the bad behavior.
Yeah, they can't touch.
No, that's right. None of that. But tell them to treat them respectfully. Don't start shunning them and talking behind their back, and don't suddenly change their shifts or whatever the case may be. Give them some examples of things and tell them to be basically on their best behavior, and make sure that you tell the employees and the supervisors that they are required to report any actions of retaliation that they see or that they think might be retaliatory, because, again, as the employer, it's your obligation to act on those complaints as well. And And retaliation is a huge issue. The plaintiffs' lawyers, they like those cases better than the actual harassment complaints themselves. They're easier to prove.
Absolutely, they'll take a retaliation case any day over a discrimination case.
Yeah, they're much easier to prove. So very important there. You're also going to want to identify any policies and handbook provisions that may be implicated by the particular complaint that you've got. Again, assuming it's a harassment complaint, go ahead and pull out your handbook and look at the complaint procedure and what your policies say on how you might handle these or who people are supposed to talk to. Of course, it could be some other sort of issue in the workplace and that you may have a policy on. Go ahead and pull those policies and get a refresher of sort of what the company documents say. And then go out and obtain and preserve the relevant documents. This may be memos, it may be employee evaluations, maybe this person has been accused of doing this in the past and there's a note in his or her file that says, hey, this happened 15 years ago. Go and pull that documentation so that when you get ready to do your investigation, you've got as much information as possible. Don't forget about IT. Emails. You probably have and hopefully have a policy in place that says that, company email, company computers, anything sent or received on them are basically fair game for the employer to look at and use that policy. Go and retrieve emails. The harassing may have been occurring over emails or, it may have a lot of good information for you there. So I would definitely go get that information.
Sharolyn, what do you think about surveillance in the workplace?
Well, if you have policies in place and if you've already got cameras up and you've told the employees, look, we may have cameras in the public places, maybe out in the yard, to prevent theft. I mean, you may have them out there. You may even have them in the break room. In the break room, exactly. In the showroom floor, anything like that. And you've got policies on that, and they're compliant with state law, and make sure that they are. Then, yeah, I would pull them. I mean, again, if somebody says that this happened on this specific day at this particular location and you've got videotape, of course, go pull it. I don't know if I'd start installing cameras and then start putting them in right then and there if you didn't already have it. But I would definitely, if you've got the information there, I would use it. Now, we get questions about, well, should I start recording employees' telephone conversations and things like that? And I would say no.
Don't go to my espionage shop down the block and buy my wiretaps. Okay.
No, that's probably not advisable. There's a few problems with that. Number one, it's just creepy. But but more importantly, there are federal and state laws that prohibit that kind of behavior under certain circumstances. I mean, in certain circumstances it is allowed, but that I would not recommend doing that 99 times out of 100. Okay, so let's talk a little bit about the basics of the employee interviews because that's crucial, obviously, to your investigation. You're depending on, or the investigator is depending on the employees to provide the information. The first thing you've got to do is identify potential witnesses. And, that's going to be people who may have experienced harassment themselves from the same person. It may be people who are just co-employees that may say, well, I've been working next to, this person for the last 15 years, and I've never seen that. Or it may be people who you think were witnesses to the potentially harassing behavior. Also, don't forget that you're identifying potential witnesses for the person who's been accused as well. That person may have 5 or 6 people that say the exact opposite of what the complaining employee is saying. So, again, the idea of this investigation is not to prove that what they said is true. The idea of the investigation is to find out the facts and then make a decision based on all the information that you get. So it needs to be a fair investigation, and that includes the witnesses that you choose to talk to. You should consider, like Kathy said earlier, having 2 interviewers or 2 people doing the investigation. That kind of comes in handy. Again, one person can talk while the other person can take detailed notes. It's difficult to do both of those things at the same time, especially if you're getting a lot of new information. And what can happen in these interviews sometimes is somebody says, oh, yeah, I saw him doing, this, and then you really need to go down that path. But this is kind of new information to you. And so it's hard to write and do that at the same time. also, you want to keep it conversational as much as possible with the person.
And not have your head down taking notes. Right?
Exactly. And so if you're taking notes, that also gets a little bit sort of, I don't know, just breaks up the conversation and may not get as much information. So 2 people in there is a good idea. The other thing is the employee who's being interviewed may be more likely to tell the truth. If they know there's more than one person who's going to say they said A, B, C, and D in the interview, and it's not just a one person's word against the other. So that can be helpful. And we've got on here that before you do the interview, you're going to want to prepare an outline of the subjects that you want to cover, and that's true. Again, be careful of what you put in the outline. Be careful of the words that you use, because all these documents, that are used in this investigation could become exhibits at trial or in motions, and so you need to be mindful of the words that you're using for that.
It should not be number 1, interview accused, number 2, prove accused is guilty.
Right.
Okay.
Exactly. Okay. So just be careful with your wording there. So the question then comes up: do we tape the interviews that we're going to have with these witnesses? And I don't know, Kathy, you agree?
I don't think so.
Yeah.
I think that may inhibit the desire to come clean on things, and it starts to make it look more like a Law and Order episode, right? Where you're in the jailhouse.
I completely agree. It's intimidating to sort of have that sort of interrogation going on, and then you've got this tape recorder that's sitting in the middle of the table, and people are nervous anyway. They're not particularly comfortable in their talking, and so you want to make it as comfortable as possible. And tape recorders are just sometimes not conducive to that. The other thing is, tape recorders always sound like a good plan, and a lot of times they just end up not reflecting what you think they said. We find this a lot in lawsuits. Somebody will come in and say, "I've got a tape recording, that proves everything I've just said," and then you turn it on, and it just says completely the opposite.
Well, plus from the interrogator's position, you think you sound pretty smart sometimes when you're asking these questions. You go back and listen to the tape or see a transcript, and you think, "Oh my gosh, I'm nowhere near as smart as I thought I was." So I think you can correct that a little bit when you prepare a written statement after the fact and ask the employee to sign the written statement.
Absolutely. And one other little thing too is if you've got a tape recorder there, the employee or the witness may use it to sort of make a lot of self-serving statements or to just support their position, as opposed to really giving you candid information. And so,
but if you're going to use a tape recorder, make sure it's on the table. Do not try to surreptitiously record an employee.
That's exactly right. And before you do that, also check your state laws. Check with your attorney and make sure that there aren't things that you need to put in place, like have waivers or anything like that. And again, each state is different or can be different on that. So make sure you check that if you are going to choose to do that sort of thing. So some of the interviewing basics. One thing is the order of the interviews. And the first person, obviously, you're going to talk to is the complainant. Again, that may be the person who's been harassed. It may not be, but that's the person who's making the complaint and is going to have the most information to sort of get you started. They're going to give you the roadmap of where you go next. Which witnesses that you're going to talk to, which ones are more important than the others. They may say so-and-so was sitting right there. And so that's obviously an important person, whereas somebody was in the same room, but they don't know if they actually observed anything or not. That's a lower importance witness. But they're going to give you that roadmap.
Sharolyn, here I have to say I disagree with our slide here, because we say you interview the complainant and then we go immediately to those people who have relevant information, and then generally interview the accused last. I disagree with that. I think that you interview the complainant and then you have sort of a mini interview briefing with the accused, where the accused has been notified that a claim's been made, that we are going to conduct an investigation. We don't know the complete facts at this point in time, and we would welcome any suggestions that the accused has on witnesses who might be relevant to his or her side of things. Then you circle back at the end with the accused once you have a more complete picture.
Right. So you're talking about like sort of a little mini interview up front that sort of, again, helps you get their their witnesses and things like that, and gives you a more full picture before you get the full-blown interview with the person.
Plus, I think that looks more fair. I mean, what if I'm accused of sexual harassment and I learn that an investigation's ongoing and nobody's even told me that there's been a complaint made? I mean, I think the only decent thing is to come to me first and say, this is what's happening. Give us your suggestion on how we proceed here.
I think that I completely agree with that. And again, if you when you're doing these sorts of things, if you think about it as if, how would it look to you if you were on the jury? Then
juries like an employer to treat people fairly.
Right, and I think that is completely fair. And again, it helps you get a better picture of really what was going on, because again, it's not your goal to prove that the accused is, or the person who's making the complaint is right. It's your goal to actually find out the truth, and so I think that's a good point. Now, one thing about sort of working with the witnesses and doing the interviews is, and we get this question a lot, don't put a bunch of witnesses in the same room. Okay, because people inevitably start taking on other people's ideas or thoughts or just what they remembered about the facts. If you've got 3 witnesses, do them independently, because, again, they just start adopting information from other people, not on purpose necessarily.
It's just human nature.
Right, it's just what we do. And so don't put them all in a room and do it all at one time. Do it individually. Keep the process moving and avoid the witnesses then coordinating stories, because there's the one thing where they just start, accidentally adopting information. There's another side of it where maybe somebody doesn't like this person and they might start actually sort of coordinating their stories. So try and avoid that. Now, what do you cover in the interview? First thing you're going to do is explain the subject of the investigation, but you're going to do that in a very broad sense without revealing too much information. You don't want to somehow be feeding information to the person that you're going to be interviewing. You want them to actually give you the information. So make it very, very broad. It's crucial to obtain complete and accurate information. Ask the hard questions. If somebody's really vague with their answer and they start fidgeting and they start looking down and you can just tell that they're not giving you information, you need to ask that next question. And it may be uncomfortable. It may be unpleasant for both of you.
It may involve words that you don't want to use.
Exactly. It may be, but you have to ask those questions. This is your opportunity to do the investigation. Again, assure there's not going to be any retaliation. And again, let them know, once again, that there's no ability to maintain complete confidentiality or secret identity. Just be upfront. Remind them when they leave not to discuss the interview with other employees. Now, you and I both know at some point that's going to happen, but give it your best shot to not let them do that. When you're in the interview, like we started saying, you want to ask open-ended questions. Have you ever seen any harassing behavior in the workplace? That's a really broad question, but that's a good place to start. And they may just start spilling, in which case, it gives you an idea of how bad the problem is. On the other hand, they may just say, I don't think so. What do you mean? Then you dig down a little bit more and you provide a little bit more detail. So, you're just going to have to gauge it a little bit at a time. Again, use follow-up questions and get examples. Examples are crucial. If somebody just says, he harassed me, but they can't tell you when or, where or what it was, then it's just a feeling.
We get that all the time, too. So that's really crucial to get those specifics.
Absolutely. And those specifics are going to be key, again, to whether or not you did an appropriate investigation. Ask each interviewee, including the employee, if there are other people they need to talk to. And again, is there anything else you think I need to know? You want any people who are going to be crucial to the investigation. That doesn't mean you're going to go interview every employee that somebody mentions. You're going to have to gauge that a little bit. Some people just might not be that important to talk to, at least at this juncture. You might need to later, but step at a time. And then we do this all the time. It's the last question. What else do I need to know?
Anything else? Anything else you think I need to know?
You may get a lot, and you may get nothing. You may find out about all sorts of stuff you didn't want to know, but nonetheless, it's a question that needs to be asked.
Okay, so let's assume that you feel like you've covered everyone, all the interviews are done, and you've gathered the evidence that you think is appropriate. So how do you pull this all together in a report? Now, remember that making this investigation report, we're really talking about Exhibit A, for the jury, or Exhibit A for the arbitrator or mediator or the EEOC. This is your explanation. And you may be in a position where you're explaining this 2 to 3 years down the road when memories have dimmed, or even when people involved in the investigation are no longer employed. Your investigator may not be with your company. But that's okay, because this document is what we call a business record. It's maintained in the ordinary course of an employer's business operations, and it can come into evidence without the testimony of the investigator himself or herself. So it's a very important document. It's your Exhibit A. So because of that, maybe we shouldn't have to say this, but, there shouldn't be typos and bad grammar in it. So have somebody look it over before you finalize it, and this is probably when your attorney comes in handy. You run a draft of this by your attorney and let your attorney make changes and revisions that he or she thinks is appropriate. So how do you put it together? Well, you're telling a story, so you start at the beginning. How did this issue come to your attention? How did it come to the company's attention? This is very important, especially in a sexual harassment case where you've got that grievance mechanism in place because your policy is meaningful and well-written. And, it comes through that process. You get a complaint made through that process, or perhaps the person never takes advantage of that grievance process. That's very important, too, for your defense, because that may be a complete defense for you. So how it comes to your attention is important. Then you describe the course of the investigation. List the steps that you took, list the leads that you followed, list the people you interviewed, and this is like a summary. So you don't have to go into all the minutia in this summary. I would attach, you've gotten your witnesses to sign off on their statements. I would attach your witness statements as exhibits to this summary. Go back through and list, if you've got a history, if this employee that you're investigating has a history, you detail that you went to the personnel file and you found that he'd been counseled for inappropriate, comments in the workplace in 1999, and then again in 2002, and then again in 2005. That prior history is important. And you know what? You may have people who you interview and they just say, I don't want to talk to you. I'm not going to talk. I mean, if you've got someone who's not cooperative, detail your efforts to talk to them and detail the fact that they wouldn't provide information.
Because that's going to be one of those things that comes up later. They're going to say, well, they never talked to me, or they talked to me and didn't ask me the questions. And if you've done all that and you've documented that, then you're better off.
Exactly.
They can't change your story later.
Right. So don't forget to include things like any applicable policies or handbook provisions. Like I would attach your sexual harassment policy if this is a sexual harassment investigation as an exhibit to this summary. You want to list what you determined, the facts you determined, and I go back to the old journalism school: who, what, where, when, how, and why. Ask those questions and put those specifics down in this summary. Any other significant documents, emails, letters, inappropriate photos, things like that ought to be part of this as an exhibit. And again, how have you handled these things in the past? Consider your past practices. But what you're wanting here are your factual conclusions. Now, sometimes investigators will be given the charge to gather the facts and make a recommendation. That's a little bit different than, I think the majority of times, probably 9 times out of 10, you're investigating, you're gathering the facts, you're reporting these facts to someone, perhaps in management, who is going to make a decision based on how you've gathered the facts. But you're gathering them and you're making conclusions because you're deciding whether or not someone is credible or someone is not credible, whether or not this actually happened, in your opinion, based on witness testimony.
This is one of those areas where I think it's really important to probably consult with your attorney as you're creating this report. Factual conclusions are one thing, legal conclusions are another. And a lawyer can help you sort of draft those factual conclusions in a way that don't have a legal definition or a legal implication specifically. In other words, it's found that so-and-so engaged in inappropriate behavior.
Well, or that, your facts, that, as you find, are that the complaint of touching appears to be true because witness X saw this happen. You don't say in this that he assaulted and battered her.
Right, exactly.
There's a difference between facts and drawing a legal conclusion from them. I said earlier, I like consensus decision-making. So I like the recommendation going to a group who then considers the facts, the report going to a group who then considers the facts, and then they make the decision on what the discipline ought to be.
And I think that's not a good idea as well, because when you're involved in the investigation, and if the allegations are really bad and the witnesses confirm those things, if you're also the one making the decision, sometimes you can be sort of overly influenced maybe by what's come out in the investigation and people you've talked to, and maybe somebody started crying or what have you. And so another party making the actual decision may be better.
You may believe the complainant, you may not. And you may end up determining that you don't think the conduct that occurred was as serious as what was claimed. Or you may find when you investigate that the complainant was involved in the same kind of, joke-telling or naughty behavior in the workplace, himself or herself. But the thing that you need to remember is that as an employer, you're allowed to use your good faith belief in reaching those credibility resolutions and those conclusions on the facts, because most states have a really good body of law that basically says courts don't sit as a super personnel board. They're not going to second-guess business decisions made by employers in good faith, even if the court might reach a different decision or thinks that the employer made a bad decision. As long as it's made in good faith without some sort of discriminatory or bad motive, you're not going to be second-guessed. Okay, so then you've reached a conclusion, and so what do you do? How do you inform the employees of what's happened? Well, you'll find that there's some disagreement on this, but what I think is appropriate is that if I'm complaining of sexual harassment, for example, and my employer is conducting an investigation, the last thing I want to hear from my employer is, we've taken care of it. It's under control. I think that you owe the complaining employee some sort of summary, and I'm not advocating that you turn over your internal summary that you've created, which pulls all this together, but some sort of summary that provides to the complaining employee a little bit of information about the course and the scope of the investigation, the fact that interviews were made, and that action is being taken, or if no action is being taken, that you're unable to corroborate his or her side of the story. I think that goes a long way toward keeping an employee from picking up the phone and calling his or her lawyer or heading down to the EEOC when they think that things have been taken seriously and that a good faith and fair investigation has been performed. I think you ought to express your appreciation for the reporting, and again, emphasize there should be no retaliation, that this report was taken seriously, and they are to let you know if they feel like they're the victim of retaliation. Again, ask that they keep the investigation and the results of it confidential. I think sometimes employees worry that something's going to be placed in their personnel file. If this is, a complaint that's been made in good faith, I mean, why would you put this in the complaining employee's personnel file? And let them know if there are any questions that they should contact someone within the company for clarification.
Kathy, you said you want to give a summary, and I agree with you that you give them a shorter summary than you have in your overall report. But do you actually give them a written document that's a summary, or do you want to do it orally?
I think you can go either way on it. I think that's, again, one of those instances where you use your best judgment. Look, if it's a summary that it's not going to hurt you. I mean, if it conflicts with your internal summary that you've done, that might hurt you. But if it's in, if it's all straight up and good, that summary's not going to hurt you. It's just another evidence of your attempt to conduct a fair investigation.
And I think, too, a written summary actually tells the employee that we're not afraid of documentation.
Right.
Sometimes it may actually say, okay, well, they really did, and they did everything they said they would. Otherwise, they wouldn't have given me a document saying so.
Plus, we all know that employees hear things differently. So you give them an oral report, and then, they didn't hear what you said.
Exactly.
Right. Okay. So then, what about the person who was accused? Do you inform that person of the results? I think they're entitled to notification as well. And while I wouldn't give them your internal investigation report, I do think you ought to give them a summary of the findings. And here's an area where you're going to find considerable debate among lawyers is, do you disclose to the person who complained the discipline that you imposed? Let's assume that you found everything that the complainant said to be true, and you've suspended the accused person for 5 days without pay, or you've demoted. I mean, do you report that? I don't know what you think, Sharolyn. I ask you to tell me, but I think that you need to let the complainant know that you've taken some disciplinary action. You've got to balance that with the right to privacy of the accused. But I would want to know that you took me seriously enough that you took some steps to discipline the guy who's been touching me.
I think that's right. I think it's a more sort of, we've taken some action without a lot of specific. Now, obviously, if you've terminated somebody or if you've put them on leave, that's going to be a fairly obvious thing.
Right.
But if there are other things that, you gave them, they're not going to get a bonus this year, for instance, or something like that, I don't think that I would advise telling the complaining party that information. And I guess if you are going to do that, I would make sure that you tell the accused that you're going to do it before you do.
Agree. What if you just can't reach a conclusion? I mean, it is a he said, she said situation. And a lot of them end up that way. So what you do is you explain how everything conflicts and why you can't resolve this conflict and why you can't make a credible determination. And that's an instance where, to the employee who's complained, you explain that and you say, we're going to monitor this in the future, and if anything happens, you need to report this to us in the future. One thing that is very important, and I'm going to hit on this very briefly, but what do you do with this report and all the summaries and everything? Well, you need to keep all this in a separate, secure file for the investigation. That ought to have your witness statements, your handwritten notes, your emails to and from the players in the investigation where you've scheduled interviews or where you've sent drafts of witness statements asking them to sign or make changes. The complaint ought to be in there, notification documents of the investigation results, and anything that the discipline or any kind of remedial action, that all ought to be in there. Keep that in a secure place. Keep that for 3 to 5 years at least. If you're networked and you've got people who might have access to all that information on a computer, then take steps to secure that with a password or some sort of encryption program. But that document and that file, that's your defense if you get sued.
So what do we do in the investigation aftermath? We've come to a conclusion, and we've obviously got the employee who made the complaint that they have been harassed. And as we said earlier, retaliation is a huge issue, and it's what a lot of the lawsuits are really based on. Retaliation can be real retaliation, or it may just be perceived. A lot of employees, once they've made a complaint, suddenly everything that goes wrong in the workplace they see as retaliation, and so it isn't always retaliation. But the question is, what is and what isn't? The case that I mentioned earlier, there's a Burlington Northern case where the Supreme Court, it actually created a little bit of a fuzzy description of what retaliation is. But what the court said is that an employee must show that the employer's action was, quote unquote, material to a reasonable employee.
That just clarifies it, doesn't it, right there?
It's clear as mud. It's clear as mud. So, material is going to distinguish between significant actions, things like job transfers, pay reductions, or outright abuse, to more trivial things like personality conflicts, bad manners, things like that. And the reasonable employee is supposed to be just that, the reasonable employee. But I will tell you, it's still just not that easy to determine. In the Burlington case, the employee made a claim of harassment. She lost on that case to the jury. She did not win her harassment case, but they gave her a large sum of money for the retaliation, and the U.S. Supreme Court upheld it. She received no reduction in pay at all, but what she did receive was a job transfer, and during some other things, she had received an unpaid suspension. Well, the company had actually repaid her the money that she lost during this suspension. So at the end of the day, she hadn't lost any money, but she had received a job transfer. And the court said that was enough for retaliation. So just very briefly, there's so it's sort of fuzzy. Things like denying tenure, denying a raise are obvious forms of retaliation. Things like shunning employees, giving people the cold shoulder, or just personality conflicts have been held to not be retaliation. But again, the point is, it's all over the board, and it's a little difficult to know. And so you need to be telling employees to just be on their best behavior.
It should be business as usual.
Exactly. Now, you are not going forward prohibited from making legitimate, non-discriminatory business decisions with respect to the complaining employee, and that gets really difficult, I know. But the complaining employee, if they're going to say that you retaliated, also must show that there was a causal link between whatever action you took against them and their complaint. So, for instance, if you've had an employee who had 3 forklift accidents and had people complaining that they thought they were on drugs, that all happened before they made a complaint, and then you have complaints about that same behavior afterwards, you can take whatever disciplinary actions you need to take. You just need to know that that's not going to keep them from saying you retaliated against them, but the point being is, at the end of the day, a court is going to hopefully find that that was legitimate because that pre-existed any complaint. There's no causal connection there.
Okay, so I complained of sex discrimination or sexual harassment. You conduct an investigation. You determined that what I was complaining about was true, and you've disciplined the person who was harassing me. And that person is still in my workplace, and he just never looks at me. He never walks down my hall. I used to get invited to go to lunch with all the people in my group, and I don't get that invitation anymore. And I come to you, you're an HR director, and I say, I'm the victim of retaliation. What do you do, Miss HR Director?
You follow the same steps. Suddenly, you've got a complaint, and it's just like getting the original harassment complaint. What you need to do is potentially start an investigation, and if there may be more to that story, and you need to find out what that is. So it comes full circle, unfortunately,
yes.
and that is the difficult thing. But the idea is, you want to know if retaliation is going on, and if they come to you and they say, I'm being retaliated against, and here are the details, then an investigation needs to ensue. Now, the examples you just gave me probably fall in the category of personality issues or just the cold shoulder. But again, if it starts with that, there may be other things that you find out after you talk to a couple of witnesses, and so you really need to be aware of that. And so you do another investigation.
So we leave our listeners with the vicious circle. Well, that concludes our presentation today. We hope that we've given you some suggestions and tips for how you conduct yourself in this area, and we will answer. We don't have time. We're running over. We don't have time to answer any questions live, but we will answer the questions that you've sent in on a timely basis. Yeah.
And I think some of those questions were answered during the duration of the presentation, but we'll still cover them again just to make sure everybody got those. Before we close, just a few quick reminders. First, you'll be getting a follow-up survey about this webinar. Please take a few moments to complete that questionnaire. Your feedback helps us improve our events, as well as letting us know what is on the top of your mind so that we can kind of plan those events going forward. Also, as I mentioned earlier, those who pre-registered for HRCI credit will receive an email in the next day or so with program details about today's webinar for recertification submission. Later this afternoon, an archived version of this webinar will be uploaded to our webinar resource page. The downloadable version of the presentation materials is also available there. You can easily access that resource page from the homepage of employerlink.com as well as McAfeeTaft.com. I want to thank Kathy and Sharolyn for presenting today's webinar. And on behalf of the law firm of McAfee Taft, thank you for joining us for another Employer Link webinar. See you next time, and have a great afternoon.